Hi, I'm Jay Lutzky, an attorney. Several clients have asked me recently, if I file a bankruptcy, how will that impact or affect my significant other? A few things we need to discuss is what is a significant other. It could be a husband, a wife, or it could be a relative, a boyfriend or a girlfriend. As long as you signed papers and they signed papers regarding that debt, it may have an effect on them. It's possible a credit card is in your name alone. It's possible a credit card is in their name alone. It's possible it's in both names. So let's go through the scenarios and analysis. If the bills are in your name alone, you could file a bankruptcy, wipe out all of your bills that are dischargeable or can be eliminated by the court, and your significant other still has their bills. It does not impact their credit score or any way or shape impact them because there's no bills in both names. Next, let's say you have some bills in your name and some bills in both names. You could still file a bankruptcy, wipe out your bills, and wipe out your responsibility by getting a discharge on the bills that are in both names or jointly held. However, your significant other will be impacted then because your name is eliminated for the bills that are joint or in both names, but they're still responsible for those bills since they co-signed those bills. So your significant other could possibly also file their own bankruptcy, and that way they would eliminate those bills and those debts. If you're married to one another, you could file a joint bankruptcy. One filing, both people are listed on the petition, both people's incomes are listed, both people receive that discharge or elimination of the debts. Now, if you're not married to the person, you can't file a joint bankruptcy. You would have to file a bankruptcy by yourself, and they would have to contemplate filing a bankruptcy on their own. If they don't want to file a bankruptcy, that's up to them. But you do have the option of filing jointly. Other things to consider if you have a joint bank account with an individual where both names are on the account and one of you gets sued and lose that lawsuit and there's a judgment against you, the creditor can garnish or withdraw the money from that joint bank account because it's in both names. So if you're contemplating a bankruptcy, you need to really sit down and analyze it carefully. My suggestion is when you're ready, make a list of the bills in your name, make a list of the bills in your significant other's name, make a list of the bills in both names, and put down the amounts to figure out how much it is in each category, and we could work through the options of what's best for you and your significant other. Thank you very much.